Swayam Prabha. Digital India. Educated India.
The next exception that we have is cases of statutory exception or necessity, and the word exception is already mentioned out there. So, buyer is incompetent if he is the only person competent to perform an act. Now, God forbid there is a natural calamity, say for instance, there is an earthquake or a flood, and one person is very well technically equipped to deal with the public order and the disorder that has been happening, the hue and cry, and to also deal with the technical part. So, therefore, in this case, there is an exception. 9 cases of contractual arrangement, there is already a clause in the termination of a contract, so we don't necessarily need to have a hearing from both the sides, so on and so forth. Then, in case of government policy decision, now unless capricious, arbitrary, illegal, uninformed, and contrary to law, it cannot be challenged. Now, if it's a government policy decision, where it's a policy decision, generally it is not challenged. Next. Now, what are the tests to determine the exercise of quasi-judicial powers? Now, quasi-judicial bodies, first off, they are non-judicial entity empowered to interpret the laws. But please note, they are empowered to interpret specific laws, not all laws. Every quasi-judicial body is there for a particular kind of law, obliged to judge facts impartially and give solutions to back official action. Second. Third, provide remedies to situations and impose legal penalties. Fourth, functions lie in the borderline between executive and judicial spheres. Fifth, correct understanding are of practical interest and sign. Next, judicial might not mean an act of a judge or legal committee meeting for the discovery of a matter of law. Please note. Next, judicial act is done generally by a competent authority for consideration of facts and situation and impose liability or affect the rights of others. Let's see a case law. Royal Aquarium and Summer and Winter Garden Society Limited versus Parkinson. Out here, judicial means the discharge of duties by judges in a court of law, and an administrative duty is to be performed in court, which is important to determine what is fair and what is just. Next, in Ram Jawaya Kapoor versus State of Punjab, administrative authority decides question in judicial manner, not judicial action in strict sense. Quasi-judicial, an epithet for administrative powers required to be exercised judicially according to natural justice principles. Now, the second point, when the test to determine exercise of quasi-judicial bodies, administrative and quasi-judicial actions. Administrative, an act upon policy and expediency, dictate what is politic and expedient, not concerned with pre-existing rights and liabilities, create the rights and liabilities they enforce, and they must be fair. Also, quasi-judicial bodies in terms of administrative discretion, judicial in terms of produce and an objective, they must be empowered by statute to decide a litigation between parties. They should satisfy the principles of natural justice. One party may be quasi-judicial proceeding and the other the statutory authority itself. The case law here is the Engineering Mazdoor Sabha versus Hind Cycles Limited. A quasi-judicial body or act suggests 2 or more parties and an outside authority to decide the decision. Presence of 2 rival parties must to hold the statutory authority as quasi-judicial body, and no 2 rival parties judicial procedure required to be followed in quasi-judicial acts. Now, the difference between the applicability of natural justice principles. Natural justice, friends, represents a higher procedural principles developed by judges. It's not something that's written down in a statute. Next, the purely administrative acts, it acts as a natural justice principle not applicable, and it is not purely alien to administrative actions. Though in R.S. Das versus Union of India, application of natural justice principles were considered flexible, it depends upon the setting and background of statutes, rights, effected consequences, time of the case, and the peculiar facts of the case, and the correction or violation of natural justice by purely administrative act is beyond the court's jurisdictional capacity. Regina versus Dublin Corporation. And the test is the duty to act judicially if statute requires administrative authority to act judicially, action of authority quasi-judicial. So the precondition for exercise of jurisdictional capacity is in the province of Bombay versus Kusaldas S. Advani and others, quasi-judicial obligation is deduced from nature of function, though the statute is silent, and every act effecting rights of parties mandating conformity to natural justice principles is judicial. Every judicial act thus requires fulfilling to natural justice principles, duty to act judicially inferred from cumulative effect of nature of rights affected, manner of disposal, other requirements in statute. And ultimately, it does follow and work like a court. It does carry out the function of a court to uphold fairness, justice, equity, and good conscience. And second, the distinctive quality is minimum legal standards of administrative requirements. Thus, we come to the end on the lecture of growth of tribunals and why is it so important. You can go through the lecture once again, make the pointers. There are a couple of question and answers during the session that I've carried it out. Please feel free to refer. All the best.